Hi everyone, it's Kristen Darcy, and I am so honored to be here today with everyone talking about shifting our focus to be more proactive and looking after our family. And I'm so grateful to have Corey Whelan here with me from Path to Parenthood. Corey reached out last week and said, you know what, Kristen, can we put this on? And here we are today with so many wonderful experts and so much information to come. So thank you, Corey.
Thank you, Kristen. We appreciate you hosting this event. Path to Parenthood is very excited to be putting this information forward. And thank you so much to our expert speakers and to you as our host.
Well, I'm going to tell everybody a little bit right now. I have to put my glasses on. About Path to Parenthood is a national nonprofit organization which is committed to helping all people build their family. The organization has a long-standing commitment to the needs and safety of the LGBT community, and make sure to sign up for the alerts at pathtoparenthood.org. And I'm so grateful for Deborah online with us, and Richard, and I'm going to tell everybody a little bit about you, and then we're going to get right into the many questions that we've been receiving. So Richard Vaughn is the founding partner of International Fertility Law Group, and he provides legal services nationwide to clients all over the world hoping to build their family through assisted reproductive technology. Among other things, Richard volunteers at and chairs ART committee of the ABA Family Law section. Richard has served on the National Board of American Fertility Association, which is now Path to Parenthood. So hi, Richard.
Hi, good morning or afternoon, wherever you're calling in from.
I know, I'm afternoon, you are morning, I believe. And Deborah Guston is the partner in the law firm of Guston & Guston, and that's in New Jersey. And she is the adjunct professor at Rutgers State School of Law, where she teaches family law. And Deborah represents a broad spectrum of clients in family matters, adoption, estate planning, and litigation, administration, nonprofit formation and management, and other practices areas designed to meet the needs of the LGBT and general community. So thank you for being here.
Thank you.
So I think we're going to begin with really addressing the Family Marriage Act, and I know that that is such a big in the forefront of people's minds. So Deborah, can you address that right now?
Sure. One of the most prevalent questions that I've had since the election is my marriage safe? Will I be able to get married? And basically the answer that we have at the moment is yes. Marriage came to all of 50 states through a Supreme Court case, Obergefell, and it would take a long time and a lot of specific changes to happen for Obergefell to be overturned. So the first thing that would have to happen is that there would have to be a case that would be brought somewhere in the United States that challenged the Obergefell ruling. And that would have to wend its way up through the court system in a state or through the federal court system until it got back, if it did, to the United States Supreme Court. We'd also have to see that the total makeup of the Supreme Court would have changed. And at the moment, although there is an open seat, and we don't expect it to be filled with President Obama's nominee, that slot belonged to a conservative justice to begin with. So even if President-elect Trump appoints that nominee and that nominee is confirmed by the Senate, the makeup of the court is not going to be any different than it was at the time that the Obergefell ruling came down. The second thing that we know is that there are many, many states across the country who had marriage equality either by statute or by their own courts systems. And so you can all of our listeners can go back to their own state's history and look to see whether there is any opportunity that even if 10, 15, 20 years from now, there was an issue that overturned Obergefell, whether their marriages would remain safe in their own state. But again, the chances of Obergefell being overruled are extraordinarily slim, and it doesn't appear that that is something that is on the radar of the incoming administration. There are other things concerning marriage that I'm sure we'll talk about today that may be impacted by the new administration, but not the very fact of marriage equality itself.
Well, thank you so much for that, because that has been discussed and brought up, and I'm sure all of us, have had clients reach out to us about that. And it's so, I think for me, as you all know, I come from the emotional component. I work on that foundation to move forward with whatever you want to create. And I think just having that as a peace of mind, and thank you so much for sharing that. The next question that keeps rolling in since we started sharing that we're having this event is that of your children and their birth certificate. And I know both of you are going to address this question both from surrogacy and also from domestic. So can you address that first, Deb, and then Rick can jump on about that?
Sure. So let me talk about birth certificates in the context of adoption. There are many couples around the country where, and I'll start by talking about lesbian couples, where a child is born into their marriage. And as a result of that, both women are on the birth certificates. But let me explain what a birth certificate is. A birth certificate is a record. It is created by the parents. So it is a self-reported record. And state officials must accept that record and the facts that are put down on the form that you fill out as being true. And they will record that and create this record. But a record is, number one, the birth certificate is not proof of parentage. It is a document that can be evidence of who a parent may be, but it is not an absolute proof of parentage. The second issue with the birth certificate is that it is generally not a document that across all 50 states is afforded what we call full faith and credit. Full faith and credit is a concept in the United States Constitution that requires every state to recognize certain aspects of another sister state's court judgments, orders, and laws. But generally, birth certificates, because they are not absolute proof of parentage, can be challenged. And so it continues to be our advice in an adoption context that where if a child is born into a marriage, into a same-sex marriage, that the non-legal parent, the non-gestational mom or the non-biological dad move forward to do an adoption. To wrap this up, I want to assure everybody that there's a real reason for this, not just that that birth certificate is not proof of parentage. There are now 2 United States Supreme Court cases which require states, no matter what their public policy is, no matter how friendly or unfriendly they are to LGBT parents, that require those states to recognize and honor a judgment of adoption as being proof of parentage. This is the law of our country, and it is an adoption judgment is the currency that gives us the right to say to another state, you must recognize the parentage rights of this other parent. So, as I said, we continue to recommend that no matter what the birth certificate says.
And speaking in terms of surrogacy, for the most part, most states require that we have a court order to declare that the intended parents are the legal parents and that their names be placed on the birth certificate. So again, it is the foundation based on the court order on which those parents get placed on the birth certificate. So that's, again, on the same basis that an adoption order should be given full faith and credit, we would say that a surrogacy parentage order should be given full faith and credit as well. I've even had some states recognize other states' court orders of parentage. So for instance, in many cases, we have like the ability to get a court order of parentage in California, and the birth may be occurring in a surrogacy case in, let's say, Arizona. And Arizona, even recently, within the last week, has said they will still honor that court order from California, because we have that recent Supreme Court case. I think is it VL versus EL or EL versus VL? I always forget the order, but that was a recent Supreme Court case, essentially validating a same-sex adoption order entered by a Georgia court that the Alabama courts had tried to invalidate. So even in the surrogacy context, attorney generals in other states are recognizing the orders entered in other states. It does raise the question of whether there are certain states such as Illinois, Vermont, and Washington that often will produce birth certificates on more of an administrative basis. In Illinois, of course, there is the Illinois Gestational Surrogacy Act, so it is statutorily based, so I think you have some foundation there. But when in doubt, you could get that supplemented by a court order, and I would argue the same for Vermont and Washington.
And another question too is about the Social Security card of the child and making sure both parents are on that. Is that something that you can address, Deb?
Yeah, sure. You know, one of the problems that has popped up over the years is where if a parent were to pass away and there are survivor benefits that are payable to the child, how do you prove that the parent who died is in fact a parent who whose work history creates that benefit for the child? So we always do recommend that once an adoption is completed, that new legal second parent, now legal because they've been recognized by the court, does go to Social Security and make sure that their information is added. What we don't want to have is we don't want to have a fight at a time when a family is grieving. Right. We want to make sure that the records are all put together, everything is within the Social Security system, so that hopefully if there is a need for a benefits claim, that there are no wrinkles and no problems. And you know, there have been some disputes with Social Security over time as to whether a birth certificate alone gives rise under the Social Security laws to recognize a person as a parent. And so again, the adoption judgment is the currency that protects really to the absolute in the Social Security arena.
So if we're doing so great about the housekeeping, because basically what we're talking about is coming up to the new year and having all your like Ori said, you know, dot our I's and cross our T's. So let's go one step further now. If you're adopted a child and it was through surrogacy, or if you're, you know, United States and had your family building, what about a passport now? What are the housekeeping items that you need to be doing to obtain a passport?
So, Rich, you want to talk about?
Yeah, either way. In the surrogacy context, again, we start with the court order granting parentage to the intended parents. Their names go on the birth certificate, and on that basis, they are the ones that fill out the passport application for a child born here in the U.S. So if you have that court order, you still have that foundation of legal parentage. As far as the immigration rules go, I'm not an immigration attorney, so you know, with a caveat here, my layperson's perspective on this is that these immigration rules are decades old. These are not going to change overnight, and I don't think these are the concerns for the Trump administration. That's just my short version.
Right, and Rich, I agree, but I do think that, first of all, it's very important that those passports be updated to include the second legal parent. Obviously, this is more protective of the child than it is really of either parent, because obviously we do see problems where there are difficulties in a relationship and one parent wishes to travel with a child without the other's permission. And if only one parent is listed on that on the passport, then that parent will be able to travel with the child and the other will not be able to interfere, nor will that parent be able to travel with the child independently, him or herself. So making sure that these types of identification documents for a child reflect both legal parents is very important for the child's protection.
Deb, can I jump in? Sorry. The passports don't list parents. They're just issued in the name of the child. Of course, they're based on the application, which
On the
has the birth
application,
certificate
right.
and parents. So it does back up to the birth certificate and then therefore the court orders if you have them.
Right, and the passport can't, if the child does have two legal parents, they both either have to be present at the application, or one has to sign an affidavit that they consent to the issuance. So, but again, if you know, if customs officials or immigration officials are looking for whether or not a child is rightfully being let out of the country or let back into the country, usually that does require the consent of the second parent. So we see this a lot in divorce cases where there's unauthorized travel. But the one other thing, while we're talking about passports and identity documents, maybe I can just jump in because there may be some questions, and it's not really the total focus of what we're doing today. But one of the things that we're really recommending is that if you are transgender, that now is the time to get your identity documents in order. The transgender community is the one community that we are feeling most concerned about in terms of legal protections and in terms of being able to move about and do the things that the transgender community needs to protect themselves and have the issuance of identity documents. So to the extent that anyone is transgender, is in preparation for a gender affirmation process, has friends or family, this is the time to start thinking about these things. This is the one community within our LGBT community that I think we're all most concerned about right now.
And what are the steps that they should do right away then? And of course, we're doing this in a proactive manner, not to instill fear, but just to make sure, like, this is your honey-do list after this, you know, Google Hangout. What's the first step for them to do?
Well, obviously, you know, a pretty regular process would be name change, gender marker change, if it's possible within the state in which you were born, and with any requirements that might be burdensome, such as having to prove some type of surgical intervention. But knowing what you need to do in order to have your gender affirmation process recognized in documents is really the power of information is exactly what I said. It's powerful. And so learning what you need to do given your home state and the state of your birth, now's the time to put together that checklist, figure out when it's appropriate for you, and try to determine with the assistance of either lawyers or legal advocacy groups, you know, what you can and can't do right now. And how you can best protect yourself.
Thank you so much. We just got a question in, and I was hoping that Rich and Deborah can answer. It says, my lawyer told me that there was a case in Queens County Court that refused to grant adoption to a lesbian couple, stating that proof of marriage is proof of parentage. Is this going to block me from getting an adoption since I'm not the birth mother and my partner is?
Okay, so these are problems that have started to crop up, and I will say they're problems. I want to say that I don't think that judges mean to be have any ill will, but there are states that have parentage acts that allow for a determination of parentage to be made by what we call presumptions. And a marital presumption usually says that a child born to a married woman is presumptively the child of her husband. And there are very few parentage acts around the country that are gender neutral, but many judges are reading those statutes to be gender neutral because they feel that's the right thing to do. So when these cases come before some of these judges, what they are saying is, look, I think under this state's Parentage Act, you are already a legal parent, and therefore I can't do an adoption because adoptions don't get done and recognize the rights of people who are already legal parents. Depending on what state you're in, and I know about that case in Queens, I think the best thing to do is to start looking to find attorneys who are very well versed on both adoption and in LGBT rights law. Talk to some of the legal advocacy groups that cover your area. in New York, significantly lambda, and make determinations about what your best options are. Sometimes, as Rich indicated, a parentage order that he might obtain in a surrogacy case might be something that would replace a judgment for adoption, where there would actually be an order of parentage acknowledging your parenthood to the child. We have had a long debate in the adoption community and in the LGBT legal community about whether orders of parentage based on marriage are as good as other types of parentage orders. But now that we have marriage equality, it seems that the problems with that type of an order may have disappeared. This sounds very legalistic and very confusing, I know. And it is, which is why you really need local assistance from qualified counsel to try to figure out what your options are, and what possible negative issues might crop up if you aren't able to get that judgment of adoption.
I just wanted to interject. Path to Parenthood has a list of LGBT-friendly attorneys and other providers as well on our website that you can access if you're looking for an attorney that's licensed to work in your state. If you hit a snag, contact me directly. Thanks.
Thanks, Corey.
Sure.
I'm just reading and making sure. So I think right now, if we would just, Rich, maybe if you could just cover some, or bring up a topic that you think is important that we haven't covered yet. And I know we had a brief conversation before we went live. And then I'm sure that way I can answer some of the questions that are coming in, or see if that's appropriate.
Sure. One of the questions I often get almost daily now, especially since the election, is whether a Trump administration will do anything to affect the Affordable Care Act, and whether, in particular, surrogates can continue to have insurance or can get insurance, or will they lose their insurance January 1, etc. So my answer to that is, of course, the Trump administration doesn't take office until late January. The open enrollment period is currently going on now, so those who are applying now will be able to get their insurance, and they won't lose it right away. The Trump administration has said on day one they will try to repeal the Affordable Care Act, but it will take time, and most likely, at least what I've been hearing, is that they won't repeal the entire thing. They will probably try to cut it apart a little bit. One of the things that has been a bigger concern about the Affordable Care Act has been, many of the insurers have argued that they're not able to afford to stay in the program because of all the requirements of the things that they must cover on every policy. So one thing that could happen is that some of the mandates could disappear. So in other words, instead of having to offer dental and vision and acupuncture and chiropractic and maternity on a policy for a single man, they could offer just what the single man needs, and therefore things could be more affordable. That's what we think may happen if there's going to be any major change to the Affordable Care Act. Of course, time will tell, but at least for the time being, there's no need to panic. All the policies that are in place now, or in place as of January 1st, will continue to be in place for the next year. We may see a change, in the next open enrollment period or by the end of 2017, but for now, things are kind of as is.
Thank you so much. Thank you. Deb, do you have anything to add or bring up? And then I have one more question.
Sure, not necessarily on the ACA, but what I do want to say about marriage that I didn't address earlier is that I think what we're going to see is a growth in state movements and perhaps a federal movement to institute what we call religious freedom restoration acts, or to enhance those that are already on the books. These are the kinds of laws that we see where there is an attempt to allow people, based on their religious convictions, to refuse services to people whose lives or practices or whatever they have an objection to. So I think this is the place that we're going to have to be most vigilant about, because I don't think your marriages will be attacked, but I think the problem is services that are usually provided to married people may be under attack. And because your marriage may be deemed so different from a different sex couple's marriage that some law in some state gives someone a right to deny you services, to deny you the ability to purchase goods or whatever. So I think on a state-by-state basis, all of us need to be very vigilant and keep an eye on what's happening in our state capitals with these types of laws, because this is where I think the attack on marriage equality is probably going to come.
Thank you. Thank you for bringing that up, because I know that that was a concern I had. I had totally forgotten to talk about that, so I appreciate it. And I have one other question, and I think then we'll have closing remarks. And this question comes in, it says, how long after a child is born would it usually take to be able to finalize going through the process of an adoption, assuming you start right when the child is born? Asking from Pennsylvania, if that matters.
Sure. This is real, it does matter because it's a very state-by-state process. In my home state of New Jersey, the adoption process would generally take about 5 to 6 months, based on court time, based on filing time, based on the time it takes to get some mandatory background checks completed. Some states are still requiring home studies, even for couples who are married and where a child is born into that marriage. So adoption law is a creature of state law. So you need to check with an attorney in your state, as well as the list that Path to Parenthood maintains. You can also check out the American Academy of Adoption Attorneys. I am honored to be its president-elect, and we have attorneys all over the country. And for our LGBT clients, our directory does specifically recognize lawyers who have expertise and interest and ability to work with LGBT clients all over the country. So that's a question that's best posed to someone local.
Deb, are you able to start that process if you're currently pregnant?
The actual court process, generally, no. Most states do not recognize the ability to adopt a child pre-birth. However, most states do have background check requirements. Those can be started prior to the birth of a child. I usually like to recommend that that happen, because once the baby arrives, you are too tired to figure out where to go and what to do. And they can take 6 to 8 weeks in many jurisdictions. So that is certainly a piece of the adoption process that could be started early, and certainly getting an attorney retained,
Right.
Getting them all the information they need so that they're ready to go the moment you call them and say the baby was born, here's the birth date, the name, and the place of birth. That will allow your attorney to get going quickly.
Beautiful, thank you.
And let me just add, speaking from California, if you had, for instance, a lesbian couple that had undergone reciprocal IVF, where one woman carried and the other woman provided the egg, you do have the ability to apply to the court prior to the birth for a parentage order. It's not the same as an adoption order, but you could get a pre-birth parentage order. So if there was any concern about timelines or trying to get things done before the laws change, you could potentially do that before the birth. I don't know if that exists in other states, but I can't speak for California.
Thank you.
And one other thing about people's concerns about how quickly adoptions or parentage orders can be obtained. Most insurance policies will say that if a child has been placed with you for the purposes of adoption, that you can put that child on your insurance. And most insurance companies also will use a birth certificate as proof that you have an ability to have a child placed on your insurance. So again, while you're pregnant is the time to talk with your insurance company, whichever policy you wish to place the child on, and make sure that you have all the documentation and know what they need so that you can get to the insurance company soon after the birth and make sure that coverage will be put in place.
And let me just add or clarify, I did not mean to suggest that those going through reciprocal IVF need to make a mad dash for a parentage order pre-birth, because laws are going to change. I don't think most of the parentage laws are going to change. Like Deb, I think the attack will be on RFRAs.
Thank you so much. Well, we're coming up to our closing time, so I just wanted to say thank you so much. I want to reassure everyone that this video will now be up on YouTube, and everyone's contact information will be associated underneath the video. But I just wanted to open it up for closing remarks for Corey and Deb and for Rich before we sign off. So Corey, do you have any closing remarks?
No, I don't. I just want to thank everybody for participating and getting this information out. I think it will go a long way towards calming people down. So thank you so much. And I also would just like to thank Meryl Rosenberg and Heather Ross for helping us create the curriculum for today's events. They are the co-chairs of Path to Parenthood's legal counsel. So thank you guys. I know you're watching.
Yeah.
Yeah, so thank you everybody for participating. I agree with Corey. This is an opportunity for us all to take a deep breath, collect ourselves, calm down. But I think the real key is after we've taken that deep breath and we've calmed down, we have to be vigilant. We have to be active. We have to make sure that our communities are safe and that we're putting our energies into protecting our families in our own local communities. And support those organizations that are out there that are doing the work for all of us, because we don't know what the future is going to hold. We have some really reasonable projections that it's not going to be horrible, but we have to make sure that it isn't.
Thank you.
Right, and I would echo what Corey and Deb just said. I basically don't panic, stay vigilant, and stay involved. Don't get complacent, stay involved.
Thank you so much, everyone. This has been such an important conversation, and I so appreciate your time and your expertise. And hopefully we'll have another conversation maybe in a few weeks and see how things are going then, another temperature check. So thank you so much, everyone. Have a great rest of the day.
Thank you
Take
all.
care.
Bye-bye.